All right, good afternoon, everyone. Welcome to session 2 of the Municipal Essentials. In this session, we will be covering the Brown Act and Senate Bill 707, which is the most recent update to the Brown Act. We'll go ahead and get started. So once again, we'll be covering the Ralph M. Brown Act, which is commonly known as the Brown Act. So in certain terms, the Brown Act can be boiled down to one word, which is accessibility. Accessibility to government, accessibility to the meetings of a government body, and accessibility to the documents of a government body. So this was created back decades ago, and it was formed after a reporter for the San Francisco Chronicle found some issues with a San Francisco legislative body, and that really sparked the initiation of the Brown Act and its, legislative acts. So in creating the Brown Act, the legislature found and declared that the public commissions, boards, and councils and the other public agencies in this state exist to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. So this was once again reaffirmed in 2004 when the voters of this state overwhelmingly passed Proposition 59. And that basically boiled down to the people have the right to access to information concerning the conduct of the people's business, and therefore the meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. So you might be asking yourself, or you might need a refresher, what exactly is the Brown Act? So the Brown Act is a set of laws which requires the governing body of a local public agency to be conducted in public, obviously except for a few exceptions, which I will discuss later. So this covers both elected and appointed boards. So it covers city councils, boards of supervisors, school boards, planning commissions, boards of public utilities, any board that is of a public nature and stems from a public agency is subject to the Brown Act. Meetings subject to the Brown Act are not limited, obviously, to face-to-face gatherings. It includes any communication medium or device through which a majority of the governing body discusses, deliberates, or takes action on an item outside of a noticed meeting. So as we'll discuss later, the Brown Act also does have jurisdiction over, for example, email correspondence. That would be subject to the Brown Act and subject to a violation. So a couple of goals of the Brown Act. So as I mentioned earlier, it's all about accessibility and openness to the public. The Brown Act aims to protect the public's right to participate in local decision-making. It also permits the governing body to privately make decisions involving confidential information, which goes back to those closed sessions. And it also enables the press and the public to fully understand and communicate public agency decision-making. I always tell my council members the best citizenry is an informed citizenry. You want to make sure that the public is aware of what is going on before city councils or boards of supervisors. You want to have the public aware of what decisions you're making. And it's always best to have those individuals come to council meetings and get involved with what is coming before the boards. So going beyond the Brown Act, the Brown Act allows a governing body to adopt practices and requirements for greater access to meetings that are more stringent than the law itself requires. So for example, a city can adopt an ordinance or a resolution that would go beyond the Brown Act. So the Brown Act is a minimum set of requirements, but any jurisdiction and any public body can adopt regulations that are stricter than what the Brown Act requires. So local policy can build on these basic Brown Act goals by creating ordinances or resolutions or policies for the public's right to participate meaningfully in meetings and to review documents used in that decision-making process. And it also can provide information the agency's right to confidentially address certain items. So if the city were to release or waive the privilege of an item that is discussed in closed session, it does have the right to do so. Obviously, there will be some redactions or some withholding for some information, but if the board chooses to waive that privilege, they certainly can do so. So the next question is, who exactly is covered by the Brown Act? So once again, the legislative body of a local public agency. So for example, cities, the city council, for counties, the board of supervisors, for school districts, the school district board, legislative bodies of local agencies created by state or federal law, any standing committee of a covered board or legislative body, and governing bodies of nonprofit corporations formed by a public agency. This has come up recently within our purview. A lot of cities are now looking to form 501c3 corporations, and they're looking to have their city council members serve on the board for those 501c3s. And so obviously when you have more than a quorum serving on that nonprofit corporation governing board, you do have to inquire and comply with the Brown Act. So that would be an example in which a governing body does form a nonprofit corporation and it is subject to the Brown Act. So what is not a governing body? What would not be subject to the Brown Act? A couple of examples here. A temporary advisory committee comprised solely of less than a quorum of the governing body that serves a limited or single purpose, that is not perpetual, and that will be dissolved once the specific task is completed. And obviously, this is typically what is known as an ad hoc committee. So, for example, if a city were to look at a traffic study of putting a roundabout in, a specific intersection, that would typically be an ad hoc committee because they would be looking at studies to determine whether or not that the roundabout is feasible for that specific intersection. It serves a very limited purpose to look at those studies. It's not perpetual. It typically is limited time, let's say 6 months or so, and it'll be dissolved once that specific task is completed. So those ad hoc committees are not subject to the Brown Act. The second type of committee that is not subject to the Brown Act are groups advisory to a single decision maker or appointed by staff. So if, for example, the council wanted one member to advise the city manager or appoint staff members to a specific limited jurisdiction group, then in fact that would not be covered under the Brown Act because it would be limited in time and limited in scope, and it would just be advisory, and all decisions would of course go back to the governing body. Meetings, obviously this is the big portion of the Brown Act. So the Brown Act does apply to meetings of local governing bodies. The Brown Act defines a meeting as any congregation of a majority of the members of a legislative body at the same time and location, including teleconference, to hear, discuss, deliberate, or take any action on any item that is within the subject matter jurisdiction of the legislative body. And you'll often hear throughout this presentation this term subject matter jurisdiction. And a lot of the times I get questions of, what exactly is subject matter jurisdiction? Well, it's anything within the capability that the governing board is able to make a decision about, whether that be contracts for the city, whether it be zoning, whether it be litigation, anything that comes within that legislative body's jurisdiction does in fact qualify under that term subject matter jurisdiction. The Brown Act does include regular meetings, which are meetings that are normally scheduled, special meetings, which we'll talk about later, emergency meetings, as well as adjourned meetings. Now, there are a couple exceptions to the definition of meeting within the Brown Act. Individual contacts, conferences, community meetings, other legislative bodies, ad hoc committees, which we just discussed, as well as social or ceremonial events. Um, Collective briefings, gatherings, retreats, study sessions, which we see a lot, as well as trainings or workshop are subject to the requirements of the Brown Act. So I know a lot of the cities, kind of have study sessions or trainings, or they like to go over kind of where the city is going, their agenda for the next upcoming year. Those would be subject to the Brown Act because you would have more than a quorum attending that meeting, and the items discussed during that meeting would fall within the agency's subject matter jurisdiction. So next we'll talk about prohibited meetings, and this is often called serial meetings in the Brown Act. So a prohibited meeting or a serial meeting are private discussions among a majority of the governing board. And these are, of course, permitted because you're discussing or deliberating a matter that is within the agency's subject matter jurisdiction, and you're coming to a decision, or you're talking about what decision you will make at the open meeting or in public. So prohibited meetings or serial meetings can occur in two ways: hub and spoke or a daisy chain. So we'll first start off with the daisy chain. A daisy chain serial meeting occurs when one person talks to another, who talks to another, who talks to another about a matter that is within the agency's subject matter jurisdiction, and deliberates or discusses how they're going to vote or how they're going to discuss a matter before, and not doing it in public. So this can occur, for example, if a mayor were to talk to a mayor pro tem about an item that is coming before the jurisdiction, and then that mayor pro tem talks to another council member who talks to another council member, and so on. That would be prohibited, because that is a serial meeting that occurs between council members with a quorum outside of a public meeting. The second example of a prohibited meeting or a serial meeting is the hub and spoke method. So, for example, if the mayor acts as that hub in the middle, which is the A in the middle, and talks to the other four council members and gets their opinion, or they deliberate on a certain matter that is coming before the agency, and already comes to a decision before that matter comes before an open public meeting, that would qualify as a serial meeting under the hub and spoke method of those prohibited meetings. So one person can act as the liaison between the other four council members to basically act as, kind of the guard of what the other four council members are thinking about or deliberating. And that would be prohibited under the Brown Act. So the next topic is, what exactly does the Brown Act require? Does the Brown Act require of a governing body, and what does the Brown Act require of a public agency? So, of course, there are different areas within what the Brown Act requires. So, agendas, notice, and public participation. We'll start off with agendas. So, agendas must be written and posted in a location freely accessible to the public 24 hours a day, advising the public of the meeting and the matters to be transacted or discussed. The agenda must state the meeting time and place, and must contain a brief general description of each business item to be transacted or discussed. Now, you might be asking yourself, well, what exactly is the notice requirement for those agendas? So for a regular meeting, which is just a scheduled meeting, whether it be the first and third Monday of every month or the second and fourth Tuesday of every month, for those regular meetings, the agenda must be posted at least 72 hours prior to the start of that regular meeting. So, for example, if your meeting is on Thursday at 5 o'clock, you must have that agenda posted by 5 p.m. On Monday evening. If your meeting is on a Monday, you must have your agenda posted by 5 p.m. on Friday. Now, for special meetings, of course, this does take a different form. Agendas for special meetings must be posted at least 24 hours prior to the meeting. And for emergency meetings, this is only for true emergency purposes. For example, if there were to be a levee that would break in the city, and the city has to enter into a contract to have the levee repaired, and there could be a loss of life or loss of public property or private property, that would qualify likely as an emergency meeting. However, we do see in some instances where cities forget to post a matter on an agenda. Now, of course, if that is 24 hours prior to the regular meeting, you can have a special meeting run concurrently with the regular meeting. But if it's within that 24-hour period, then of course you would have to push that off to the next regular meeting or set a special meeting date to address that agenda item. There are some restrictions as well on what can appear on a regular meeting and a special meeting. For example, general law cities cannot adopt an ordinance or consider executive compensation during a special meeting. So there are some restrictions on exactly what can be addressed at special meetings. The content of the agenda. So, of course, at a meeting, you can only take action on agendized items. So a lot of the times, people will address, issues in public comment. Those have to go back to staff because you can't take action on an agenda item that is not on, you cannot take action on an item that is not agendized. So for the description of the agenda items, you want to strike a balance between general and specific. And if you're in doubt, more is always better. There's that old saying, less is more. Well, in this case, more is more. More is always better. Too much detail might support a claim that an action taken is not within the scope of the description. So for example, too much detail can narrow the scope of an action. Always include the phrase discussion/action or other language to make clear that items on which action is expected will have action taken. So a couple of examples of agenda item descriptions. So the first one is discussion of a report regarding traffic on 7th Street. Well, that's pretty basic. It does give you a description of exactly what will be discussed during the meeting. However, it doesn't give you who prepared that report or exactly what the content of that report is. The second example we have here is consideration of a contract with ABC Consulting. Okay, that's fine. It does describe exactly what will be considered and discussed and who the contract is with. But the second example provided under that one, consideration of a contract with ABC Consulting in the amount of $80,000 for traffic engineering services regarding traffic on 7th Street, is a much better example of a description of an agenda item. It tells you exactly where this report is about, exactly who it's with, ABC Consulting, how much that contract is for, $80,000, and exactly what they will be doing, traffic engineering services. Special meetings. So again, we have the regular meetings and we have special meetings. Special meeting is when the governing body wishes to meet outside the regular time set for its meetings, called by the chair or a majority of the governing body. And that does vary from jurisdiction to jurisdiction. Some jurisdictions only allow special meetings to be called for by the chair, for example, the mayor. And some jurisdictions call for a special meeting by a majority of the body. Department head salaries cannot be discussed or acted upon during special meetings, as I previously mentioned. And however, the budget can be discussed or acted upon during those meetings. So non-agenda items. As I mentioned previously, there may be someone who makes a public comment about a non-agenda item and is looking for answers from either staff or from the elected officials. The Brown Act generally prohibits any action or discussion of items not on the posted agenda. However, there are specific situations in which a legislative body can act on an item not on an agenda. The first one is a majority decides that there is an emergency situation. For example, the levee breaking. That would be an emergency situation, which would likely qualify as a non-agenda item. The second option is that 2/3 of the members present determine that there is a need for immediate action, and the need to take action came to the attention of the local agency subsequent to the agenda being posted. So again, there is an instance in which emergency non-agenda items may be addressed. However, in that second instance, you can only take action on that agenda item if it came to the attention of the local agency subsequent to that agenda being posted. So if it's something that just, missed the agenda, well, sorry, you have to wait until the next meeting or call a special meeting. But in the example in which the levee breaks, that would likely be a good example of an item that does qualify for that non-agenda item. Records and recordings. This is another hot topic for the Brown Act. The public has a right to view agendas and other writings distributed by any person to a majority of the governing body in connection with a matter subject to discussion or consideration at a meeting. These, of course, are public records. A writing distributed during a meeting must be made public at the meeting if prepared by the local agency or a member of its governing body, or after the meeting if prepared by some other person. So if a writing or a pamphlet or a report is prepared, and if it is prepared by the staff or a member of a governing body, that is, of course, a public record, and it must be turned over at the meeting if a member of the public requests it, or if it's prepared by some other individual, for example, a member of the public, it must be turned over after the meeting if requested by a member of the public. Any tape or film record of an open or public meeting is a public record. So, for example, if the city videotapes or if they record a Zoom session of the council meeting or of the Board of Supervisors meeting, that, of course, is a public record. Public participation, public comment, one of my favorite parts of the meeting. There must be an opportunity for public comment on items or matters within the agency's jurisdiction, but that are not on the agenda for that meeting. The public may also comment on a specific item of business before or during the legislative body's consideration of it. Public comment may also be subject to reasonable regulations, such as length, decorum, or undue repetition. A meeting is a limited public forum for First Amendment purposes. Speech may be subjected to reasonable time, place, and manner restrictions. For example, a lot of agencies that we work with have 3-minute public comment sections. Of course, and it may be limited, for example, to 15 minutes, but the agency does have the ability to extend that if needed, or if there is a large volume of individuals coming to speak at a meeting. Another thing that we always like to say is before closed session, we always like to give the public a right to comment on the closed session agenda items. So before adjourning into closed session, it's always best to give the public the right to comment on the closed session agenda items. Responding to the public. The public can generally talk about anything within the jurisdiction of the governing body. And sometimes they talk about things that are not within the jurisdiction of the governing body. But the governing body generally cannot act on or discuss an item not on the agenda, as I previously stated. The Brown Act, however, does allow members of the legislative body or staff to briefly respond to comments or questions from members of the public, or provide a reference to staff or direct staff to place the issue on a future agenda. Even without public comment, a member may ask for information, request a report, request to place a matter on a future agenda, make a brief announcement, or report on their own activities. So, for example, you may get a comment in public comment from a member of the public about a traffic study, for example, and that traffic study may not be on the agenda. So that should be referred to staff to briefly respond, or they can put that item on a future agenda. But there is not to be any lengthy discussion on any agenda or any items that are not on the agenda. Closed sessions. A governing body is authorized to meet in closed session only to the extent expressly authorized by the Brown Act. Closed session items must be briefly described on the posted agenda, and the description must state the specific statutory exemption. The body must also make a public announcement before closed session and take public comment. The Brown Act supplies a series of fill-in-the-blank sample agenda descriptions for various types of authorized closed sessions that provide a safe harbor from legal attacks. So as we all know, there's a number of closed session items that can be addressed, but they have to be within the specific exemptions listed in the Brown Act. So those closed session items that are permitted by the Brown Act are pending litigation, and in your agenda, you want to identify one of the following types of matters. Existing litigation, so that's litigation that has already been filed and is in the court system. Anticipated exposure to litigation, so if there is a threat of litigation against the city, that would be the specific qualifier that you have in your agenda. Or the third is anticipated initiation of litigation. So if the city anticipates initiating litigation, or if there are facts and circumstances that lead to the belief that initiation of litigation is warranted by the legislative body, that would be the specific language that you would put in your agenda. Of course, there are also other closed session items that can be discussed. Real estate negotiations, public employment, labor negotiations, which is often a big one, as well as public security. So if there is a threat to legislative body facilities or the public agencies facilities, that can be discussed in closed session, but it must be held with a designated security or law enforcement personnel. So those personnel must be in the closed session when discussing that public security closed session item. So another big component of the Brown Act is, of course, social media and how social media plays a role with the Brown Act. Governor Newsom signed Assembly Bill 992 into law in September of 2020 and clarified exactly what kind of communications a public official may have via social media and what kind of communications are permitted. And this bill specifically amended Government Code Section 54952.2. So under Assembly Bill 992, government officials may communicate on social media platforms to answer questions, provide information to the public, or to solicit information from the public regarding a matter that is within the legislative body's subject matter jurisdiction. There's that phrase again, subject matter jurisdiction. However, the latter types of communications are only allowed as long as a majority of the members of the legislative body do not use any social media platform to discuss among themselves official business. And that phrase, discuss among themselves, includes reposting, commenting, and even using digital icons to express reactions to communications. Assembly Bill 992's provisions go even further than the Brown Act does. Typically under the Brown Act, a single contact between one public official and another would not constitute a prohibited serial meeting, a violation of the Brown Act. However, Assembly Bill 992's social media prohibitions go even further than the Brown Act itself does. AB 992 prohibits a member of a legislative body from responding directly to any communication on an internet-based social media platform regarding a matter that is within the subject matter jurisdiction of the legislative body that is made, posted, or shared by any other member of the legislative body. So, for example, Under the Brown Act, typically if two members were to discuss an item that is within the agency's subject matter jurisdiction, that would not violate the Brown Act. However, under Assembly Bill 992, if that conversation or discussion is moved to social media platforms, there is a higher risk of violating the Brown Act. AB 992, of course, is stricter about social media contacts between public officials than it is for in-person contacts. Just as I mentioned, under the Brown Act, two public officials of the same agency could talk face-to-face about a matter within the subject matter jurisdiction of the public agency without running afoul of the law. However, when that conversation or discussion is translated to social media, AB 992 prohibits a member of the legislative body from responding directly to any communication on a social media platform regarding any agency matter if the communication is made, posted, or shared by any member of the legislative body. So you might be wondering, well, what social media platforms does AB 992 apply to? Well, AB 992 applies to any internet-based social media platform that is open and accessible to the public. You might be asking yourself, well, what exactly is open and accessible? That typically means members of the general public have the ability to access and participate free of charge in the social media platform without the approval by the social media platform or a person or entity other than the social media platform, including any forum and chat room, and cannot be blocked from so, except when the internet-based social media platform determines that an individual violated its rules and protocols. So typically and practically today, those include Instagram, Facebook, X, TikTok, Reddit, anything of that nature. Previously, 20 years ago, that would have included, chat rooms, forum, blogs, that type of thing. But mostly today, it's limited to Facebook, Twitter, Instagram, social media platforms of that nature. So the prohibition under AB 992 affects social media commenting, retweeting, liking, disliking, responding with an emoji, and or screenshotting and reposting. So what about engagement on the public agency's social media platform? AB 992 does not prohibit a public official from commenting, sharing, or liking a social media post that was posted by the official's public agency. So for example, if a council member reposts something from their city's official Facebook page, that would not be prohibited under AB 992. That would be, of course, allowed and permitted. An issue, however, may arise if one council member shares that agency's post and another council member gives it a thumbs up or likes it or reposts that official's reposting of the agency's information. That would be a prohibited direct communication under AB 992. As I mentioned earlier, it's a stricter set of guidelines for social media than it is in-person contacts. For what reason? The California State Legislature has not revealed that, but that's the set of circumstances that we are dealing with regard to social media. So another question that I get when presenting this is, does AB 992 prohibit discussions on social media about personal matters? And the answer is no. Neither the Brown Act nor the provisions of AB 992 prohibit discussions regarding private matters. So for example, if a council member posts a photo of their grandchild at Disneyland and another council member likes that photo, that would not be considered a violation of the Brown Act because it's not discussing or relating to any matter that is within the agency's subject matter jurisdiction. The Brown Act only applies to public agency business. So anything that relates to any item that would come before the legislative body or that relates to the public agency, that of course would fall within the agency's subject matter jurisdiction. However, any personal matter or any comment about family matters would not fall within the provisions of AB 992 in the Brown Act. And now we're going to go ahead and switch over and discuss Senate Bill 707, which is, of course, the most recent version of the Brown Act and the most recent update to the Brown Act. Governor Newsom signed SB 707 into law on October 3rd, 2025, which of course makes extensive updates to the Brown Act. Notably, SB 707 revises the Brown Act to take into consideration the technological and accessibility changes since COVID-19. Although it has been described as the most significant update to the Brown Act in decades, many of the changes in SB 707 are tweaks of earlier amendments to the Brown Act. So it does tweak some things that were referenced in AB 992 and other minor updates to the Brown Act. So what I'll be doing is I'll be going through some of the code sections that were updated through SB 707 and talking about exactly what has changed under that legislation. So the first one is Government Code Section 54952.2, which was amended initially by Assembly Bill 992, which we previously discussed. And this imposed restrictions on the use of social media platforms by members of a legislative body. Those provisions about social media not communicating with other legislative body members, those originally had a sunset date, so an ending date of January 1st of this year, so just about a month ago. So those were to be repealed on that date. However, after the passage and signing into law of SB 707, that restriction was removed, making the provisions of that social media transactions a permanent fixture of the Brown Act. And it permanently allowed members of a legislative body to use social media platforms to discuss matters within the body's subject matter jurisdiction, subject to those restrictions as I previously indicated in AB 992. The next update under SB 707 was in Government Code Section 54952.7. SB 707 mandated that a local agency must provide a copy of the Brown Act to any person who is elected or appointed to serve as a member of a legislative body of the local agency. And prior to this Senate bill, distribution of the Brown Act was optional. So this does require that every single member of a legislative body, whether it be planning commission, city council, board of supervisors, school board, that they be provided a physical copy of the Brown Act. The next change under SB 707 was in Government Code Section 54953, which relates to accessibility accommodations and teleconferencing options. So under SB 707, when using traditional teleconferencing, a member of a legislative body with a disability may now participate in meetings remotely as a reasonable accommodation to their disability. Such members who, in fact, can participate in these meetings remotely as a reasonable accommodation must still participate using audio and video unless their disability requires an exception to either one of those requirements. And additionally, as is done when a member participates remotely for a meeting of the legislative body, they must still disclose whether anyone over the age of 18 is present in the room in their remote location. The next update under SB 707 was to Section 54953.4 of the Government Code. And this is perhaps the most significant addition or revision to the Brown Act. So this does impose broad requirements on what is defined as eligible legislative bodies to promote public accessibility, language equity, and community outreach in local governance. You're probably wondering what exactly is a, quote, eligible legislative body. And SB 707 defines that as any one of the following: a city council of a city with a population of 30,000 or more, a county board of supervisors of a county with a population of 30,000 or more, or a city council of a city located within a county with a population of 600,000 or more. So for those agencies, for example, in Fresno County, you have the city of Fresno to blame. Your population is over 600,000. For some smaller counties, for example, Tulare, the population is below 600,000. However, if your city does in fact have a population of 30,000 or more, you do automatically qualify as an eligible legislative body. So what must legislative bodies, these eligible legislative bodies, do? So by July 1st of 2026, so just in about 5 months or so, an eligible legislative body must also adopt at a noticed public meeting a written policy for responding to disruptions in the telephonic or internet service that prevent members of the public from attending or observing the meeting of the public body. So these eligible legislative bodies must create kind of a plan for what will happen if they were to in fact lose telephone or internet service that would prevent those individuals who are participating remotely from participating in the meeting. So in the event of such a disruption, this policy must provide that the legislative body recesses its open session and engaged in a good faith attempt to restore service to either the telephone or the internet service. The session must stay in recess for at least 1 hour or until the disruption has been addressed or remedied, whichever is earlier. Now, eligible legislative bodies must also take specific actions to encourage residents to participate in public meetings, including providing an electronic system that accepts and fulfills requests for meeting agendas and documents, and creating and maintaining an accessible web page dedicated to public meetings that provides explanations of the general meeting process, how to provide in-person or remote public comments, and provide a calendar of all public meeting dates as well as the meeting agenda. Now, some additional requirements for those eligible legislative bodies. They must also undertake reasonable efforts to invite groups that do not traditionally participate in public meetings to attend those meetings. So these eligible legislative bodies must conduct outreach to certain unrepresented groups or underrepresented groups to ensure that they have the opportunity to participate in the legislative body's meetings. Similarly, these eligible legislative bodies must also translate meeting agendas and participation instruction into all applicable languages, which this defines as those languages spoken by at least 20% of the relevant population, according to the American Community Survey. So for many of the jurisdictions, that would likely be Spanish. But there's also some jurisdictions where Portuguese may also be another example of a language that is spoken by at least 20% of the population. Another change under SB 707 comes in Government Code Section 54953.5. And this reaffirms the public's absolute right to audio or video record meetings or to take still photographs. Of course, provided that doing this does not disrupt the meeting. And the reason why this change was made, which I found kind of funny, was the legislature deemed the terms audio and video recorder and audio and video recording to be obsolete and removed these references along with still or motion picture camera from the statute. So apparently they don't believe that audio or video recording is no longer used, which Seemed funny to me. Some additional changes were made in Government Code sections 54953.8 through 54953.8.7, which created a unified structure of remote participation and teleconferencing as an alternative, and in addition to the teleconferencing provisions under section 54953. And it's specifically, these sections talk about the just cause provisions. And it expands the list of just cause items that permit members to participate remotely for reasons including, of course, but not limited to, childcare responsibilities, illness, family medical emergencies, or military service. And another provision, another important provision that was amended by SB 707 is located within Government Code section 54957.96. This specific section clarifies that existing rules about exclusion of persons who disrupt meetings also apply to members of the public participating remotely. If a member of the public participating remotely disrupts a meeting, that person's further participation can be restricted, similar to that of a person who disrupts a meeting in person, for example. So if a person continues disrupting even after receiving a warning, that individual can be removed from the meeting. Obviously, there has to be a certain threshold that has to be met there, but if there is a continuous disruption, that person can be removed from that remote participation. So you're probably wondering, well, what happens exactly if there is a violation of the Brown Act? What are the repercussions of violating the Brown Act? So the most common enforcement or action that is taken if there is a finding that the Brown Act has been violated is, of course, invalidation of the action taken. So that means that, if there was an agreement on a contract, for example, that contract would be invalidated and it would have to be brought before an open meeting of the legislative body. Now, before filing a court action seeking invalidation, a demand for cure must be sent to the legislative body or to the members of the legislative body. This demand for cure must be sent within 30 days if the violation was an open session, but in violation of other agenda requirements, there is a 90-day provision. And the governing body has 30 days to cure that alleged defect. So after receiving that demand for cure, the government body has 30 days to cure the defect noted in that letter. If the governing body does not cure within 30 days, or those 30 days lapse without curing that alleged defect, the party must file the lawsuit within 15 days of a receipt of a decision not to cure or the end of that 30-day period. So another mechanism for enforcement is, of course, declaratory relief. Before filing an action, the interested party must, within 9 months of an alleged violation, send a cease and desist letter describing the past action and the nature of the violation. After receiving that letter, the governing body has 30 days to provide an unconditional commitment to cease and desist from the past action. If the body fails to make any action during that 30-day period or does not provide an unconditional commitment, that interested party has 60 days to file an action for declaratory relief. And of course, the last violation enforcement is the district attorney or an interested party can file a civil action asking the court to stop or prevent violations or threaten violations of the Brown Act by members of the body. The district attorney or an interested party may also file a civil action to determine the applicability of the Brown Act or for a threatened future action of the body. So the district attorney, or generally any interested party, does have the ability to file civil action to remedy those violations of the Brown Act. So as I mentioned earlier, a cure that is most common is, of course, a do-over. So if there's an a violation or you get a letter, cease and desist letter, or a demand for cure, the most common remedy, of course, is just to bring that item back to council or bring that item back to the board and reintroduce that item and rediscuss that item. If taken to court, attorney fees are the major penalty along with public embarrassment. As a lot of you know, those attorney's fees can rack up pretty quickly. So it's best just to cure before having to go to court and before there's a finding on whether or not the Brown Act was violated. If willful violations are found, criminal action may result. Now, this is not a common result of violations of the Brown Act, but if there is a deliberate and conscious effort to violate the Brown Act, those individuals can be prosecuted criminally. Again, it's rare, but it does happen in cases where there is willful violations of the Brown Act. And that concludes my presentation. Thank you, everyone.